It wasn't an afterthought. It was the final lock. The Ninth Amendment. Most people have no clue what it says or does, or they just ignore it, or they get it totally wrong. It's not a grant of additional federal power. It's a firewall against it, a rule of construction meant to work in conjunction with its partner, the 10th Amendment, in support of federalism. On this episode, the forgotten history behind the long-ignored but incredibly important Ninth Amendment. But first of all, before getting to that, welcome and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, August 6th, 2025. Now, in order to understand the original meaning of the Ninth Amendment to the Constitution for these United States, we first need to understand the fundamental debate between Federalist and Anti-Federalist over whether or not to even include a Bill of Rights that happened during the ratification debates. The Federalist side saw it as a trap that would expand federal power. Not all of them. Here's James Madison, who said, this is in a letter to Thomas Jefferson. He later wrote the Ninth Amendment, Madison, but he was saying he was open to a Bill of Rights, in favor of it, with a caveat. He said, my own opinion has always been in favor of a Bill of Rights, provided it be so framed as not to imply powers not meant to be included in the enumeration. But many more on the Federalist side, well, they repeatedly warned that trying to list out some fundamental rights would actually create a scenario where eventually it would destroy liberty rather than protect it, because it would allow scheming politicians, which I guess is redundant, to expand centralized power. Here's James Iredell, who was one of the first associate justices on the Supreme Court. Here he is in the North Carolina ratifying convention. He said it would be not only useless, but dangerous to enumerate a number of rights which are not intended to be given up. Because, he said, it would be implying in the strongest manner that every right not included in the exception might be impaired by the government without usurpation, and it would be impossible to enumerate every one. Of course, we know that there's a vast reservoir of rights that aren't listed out anywhere. And Iredell explained that. He said, let anyone make what collection or enumeration of rights he pleases. I will immediately mention 20 or 30 more rights not contained in it. So you couldn't list out all the rights. That was a great concern. And this was pretty much the standard Federalist position, and was also argued in support of this position by some of the other big government guys like James Wilson, or here Alexander Hamilton in Federalist number 84. For why declare that things shall not be done which there is no power to do, he wrote. Why, for instance, should it be said that the liberty of the press shall not be restrained, when no power is given by which restrictions may be imposed? So the Federalist side is saying over and over and over, look, this is a document of delegated and reserved powers. If it's not delegated there in the first place, well, why should we add a restriction when they're not authorized to do it in the first place? But the Anti-Federalists, well, they weren't having it. And they saw two great threats in this scenario without a Bill of Rights, without specific limitations on federal power. First of all, one, Congress would try to exercise powers not given to them. They would claim additional power beyond the delegated powers in the Constitution. Threat number two, they would also twist the meaning of those powers which were enumerated in the Constitution and expand federal power that way as well, not just by exercising powers not specifically delegated, but also a construction of federal power that expands federal power. They repeatedly, in the ratification debates throughout the states in 1787 and 1788 primarily, they insisted on express declarations, despite what the Federalist side was promising. Here's Federal Farmer in his fourth essay, October of 1787, who was directly criticizing James Wilson's position that a Bill of Rights was superfluous, unnecessary, even dangerous. And here's how he put it: the general presumption being that men who govern will in doubtful cases construe laws and constitutions most favorably for increasing their own powers. Students of history, students of human nature, they understand that people with power always end up trying to expand their power over time. Now, maybe not each individual person with power. Every now and then you find some rare unicorn who doesn't do that. But over time, if you're not really clear about those delegated and reserved powers, about what rights are off limits, well, sooner or later, someone's going to find creative ways to just expand their power anyways. And Federal Farmer put it like this: all wise and prudent people in forming constitutions have drawn the line and carefully described the powers parted with and the powers reserved. The anti-federalist side, in state after state after state, repeatedly rejected the Federalist claim of rights being off limits to the federal government without expressly saying so in the document itself. In the Virginia Ratifying Convention, George Mason may have summed it up best. We wish only our rights to be secured. We must have such amendments as will secure the liberties and happiness of the people on a plain, simple construction, not on a doubtful ground. Now, even some of the most ardent Federalists, here we're back to Alexander Hamilton, even though they were denying that the Constitution would create a scenario that would authorize expansive interpretations or constructions of federal power, well, they still admitted that there needed to be limits, for example, on the interpretive methods of the judiciary. Here's how Hamilton put it: to avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. But when the Constitution was being considered in the ratification debates, it had no such strict rules. And before it got amended, it had no rules of construction, or I guess we could call it interpretation, at all. And then starting in Massachusetts, then other states like New Hampshire, Virginia, New York, and others, they all made deals to vote in favor of ratification as long as they could include recommended amendments in their ratification document. For example, like this one in New York, that every power, jurisdiction, and right, which is not by the said Constitution clearly delegated to the Congress of the United States or the departments of the government thereof, remains to the people of the several states or to their respective state governments to whom they may have granted the same. And you'll notice that that sounds very similar to Article 2 of the Articles of Confederation, which was about delegated and reserved powers, a precursor to the 10th Amendment, delegated and reserved powers. But they also have something that's a bit of a precursor to the 9th. Not super straightforward, but it's definitely there. And interestingly enough, it's not even a separate paragraph. It's really the same sentence, only separated by a semicolon. They went further with this. And that those clauses in the said Constitution, which declare that Congress shall not have or exercise certain powers, think, for example, shall not be infringed, it was one that ended up in there. They do not imply that Congress is entitled to any powers not given by the said Constitution, but such clauses are to be construed either as exceptions to certain specified powers or as inserted merely for greater caution. And again, that first half of that declaration was really about delegated and reserved powers from the Articles of Confederation, a precursor to the 10th. Here's how Kurt Lash described it. The second half of New York's declaration reflects the concerns raised by both Federalists and Anti-Federalists regarding the potential dangers of construction in the Constitution. If you list about a bunch of rights, will it be construed that this is all that exists? Federalists, he writes, claim that a Bill of Rights might be construed to imply that the only limits to federal power were the express prohibitions contained in the Bill of Rights. The second provision prohibits this kind of implied expansion of federal power. Now, North Carolina took a very similar approach. Here's their first recommended amendment to the Constitution 1. Again, this is going to sound familiar. And again, they're always connected, this 10th Amendment, 9th Amendment thing, or vice versa. First, that each state in the Union shall, respectively, retain every power, jurisdiction, and right, which is not by this Constitution delegated to the Congress of the United States or to the departments of the federal government. And then in recommended amendment number 18 in North Carolina, this was one to prevent that kind of expansive construction of federal power that would lead to power always growing. That those clauses which declare that Congress shall not exercise certain powers, I keep going back to shall not be infringed, for example, because it's so straightforward, be not interpreted in any manner whatsoever to extend the powers of Congress, but that they may be construed either as making exceptions to the specified powers where this shall be the case, or otherwise as inserted merely for greater caution. And Kurt Lash summed it up like this: North Carolina's proposals are even more specific than New York's declarations in their focus on the implied expansion of federal power. In addition to preserving the principle of enumerated power, the enumeration of rights must not suggest any extension of enumerated powers. This goes beyond preserving the principle of enumerated power and prevents the implied extension of those powers which are enumerated. And Virginia's ratification in the summer of 1788, they followed this same kind of approach. First of all, by confirming that there must be a declaration or a Bill of Rights, and that the people have a vast reservoir of natural rights. They wrote that there be a declaration or Bill of Rights asserting and securing from encroachment the essential and unalienable rights of the people in some such manner as the following. So it's a recommendation. First, that there are certain natural rights of which men, when they form a social compact, cannot deprive or divest their posterity. Among which, of course, this is not an exhaustive list, are the enjoyment of life and liberty, with the means of acquiring, possessing, and protecting property, and pursuing and obtaining happiness and safety. And that list of natural rights, of course, it's not comprehensive. It's only among them. So their 17th recommended amendment was a provision to prevent the constructive extension of those delegated powers or the specific exclusions of delegated powers. And they put it like this, that those clauses which declare that Congress shall not exercise certain powers be not interpreted in any manner whatsoever to extend the powers of Congress. And as Kurt Lash pointed out, he, in one of his long research papers that we'll be publishing over in the blog post for this episode, we see the same kind of themes over and over in state ratification document after state after state. And he put it like this: all of these declarations and proposals share a common dual approach to controlling federal power. First, a declaration must be added that expressly declares the federal government has limited enumerated powers. All powers, jurisdiction, and rights not delegated to the federal government were to be retained by the states. But second, the enumeration of certain rights was not to be construed in any manner that expanded the scope of enumerated federal power. Both the declarations and rules of construction focused on controlling the expansion of federal power and reserving all non-delegated powers and rights to the states. And of course, when we're talking about states in their sovereign capacity here, we're really referring to them not necessarily as state governments, but the people of the several states, and they can determine what they want to delegate or reserve in regards to their own state government. Now, as Brian McClanahan points out, when James Madison drafted the amendments that eventually became the Bill of Rights, he referred to and relied very heavily on these proposals from the state ratifying conventions. And he put it like this: as proposals for a Bill of Rights flooded into James Madison's hands in the months after the Constitution was ratified, he quickly realized that individuals needed assurances that their liberties would not be circumscribed by the Constitution, nor would they be left to flutter in the wind should some ambitious men usurp power from the states or the people. In the first Congress, James Madison got to work on this pretty quickly, and he made an effort to give them exactly what they asked for on both counts. But first, he acknowledged the Federalist warning about even including a Bill of Rights in his June 8, 1789 speech on the House floor introducing amendments. He said, "It has been objected also against a Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration. And it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government and were consequently insecure." Very similar to the arguments we heard earlier in the show from people like James Iredell and Alexander Hamilton, but this was repeated over and over and over. And Madison made it clear, this is a pretty solid argument, but I think I've got a fix. Here's how he put it. "This is one of the most plausible arguments I have ever heard urged against the admission of a Bill of Rights into the system. But I conceive that may be guarded against. So check it out. Here's what he said. "I have attempted it, as gentlemen may see, by turning to the last clause of the fourth resolution." This was Madison's draft amendment that was a precursor to the Ninth Amendment. And he dealt with this by basically following the example of the ratifying conventions in North Carolina, Virginia, and elsewhere by creating a rule of construction. A rule of construction is how you read a legal document. The Ninth and 10th Amendments are both rules of construction. And so the goal on this was to prevent a constructive expansion of federal power at the expense of individual liberty, of your rights. And Madison's proposal went like this: "The exceptions here or elsewhere in the Constitution made in favor of particular rights shall not be so construed as to diminish the just importance of other rights retained by the people." But he added the additional caveat, "or as to enlarge the powers delegated by the Constitution, but either as actual limitations of such powers or as inserted merely for greater caution." Again, this was following the proposals in the state ratifying conventions. Now, as it went through the process through the Select Committee in the House, they removed that second part. And as Madison explained it later in a letter to George Washington, this is because they thought it was redundant. If you say that you can't do these things, you're also saying you can't expand your power to do other stuff. I mean, this is really how it all ties together between the 9th and 10th Amendment working in tandem. And Madison explained it like this: "If a line can be drawn between the powers granted and the rights retained, it would seem to be the same thing, whether the latter be secured by declaring that they shall not be abridged, or that the former shall not be extended. If no line can be drawn, a declaration in either form would amount to nothing." Now, ultimately, they settled on this text, which is part of the Constitution as of December 1791. "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." Problem solved, right? Nope, not even close. Now, you might think that this was just a minor technical change of some legal language, or that James Madison's explanation that obviously had to be done was absolutely correct. But instead, it was a moment of high-stakes drama in Virginia that almost killed the entire Bill of Rights. I'll tell that story in just a moment, but I first wanted to mention that while I realize I'm going through a lot of detailed and important historical information here pretty quickly, it's my hope that this episode serves as a bit of a highlight reel, and you're encouraged to go out there and do more research and more reading on your own time so you can learn more, because I'm really just scratching the surface on this episode, like usual. And if you're that type of person, well, you are in luck because the TAC's got your back. After every episode, we publish a blog post for that episode. Alan Mosley does an awesome job getting that organized, consistent, timely. Awesome, we'll just say. Getting that organized. And there's a show link section about halfway down that if I did a decent job of organizing my notes, I think I probably did, Alan will include the reference links that I'm mentioning in the episode generally as I go through them in the show. So whether it's a letter from James Madison to Thomas Jefferson, or a Federalist paper, or a law review paper with some more detail from Kurt Lash, etc., that will all be in the blog post for this episode. I'll get it published a couple of hours after the live stream is done over at 10thamendmentcenter.com/path-to-liberty. It's all spelled out, 10thamendmentcenter.com/path-to-liberty. Now let's get back to Virginia, where Edmund Randolph, a real heavyweight there, first Attorney General, he was a framer in the Philadelphia Convention, a lead advocate for ratification in the Virginia Ratifying Convention in 1788. Now, he took the lead in the opposition over the Ninth Amendment. The Ninth Amendment was the issue. He thought that this new streamlined language in the Ninth was dangerously vague, and it would no longer operate as a provision against extending the powers of Congress by their own authority. He thought there would be construction to expand the power by kind of this implied idea that we were warned about early on. And because of this opposition, he got enough people on board that the Virginia House voted to delay the debate consideration of the Ninth and 10th Amendment for 2 full years. And this effectively stalled the entire ratification process. And as Hardin Brumley wrote to James Madison, he warned that rejecting those 2 amendments would likely bring the whole into hazard again. They knew that unless this was resolved, it was over. They were not going to get this Bill of Rights, and then you'd have all kinds of other problems. Now, as Kurt Lash points out, Virginia was really alone on this point in opposition to the Ninth Amendment. No one else did this. He said no other state legislature complained about the final language of the Ninth. All of these states, he wrote, knew that Madison's original version of the Ninth expressly limited federal power because his proposals had been widely published in newspapers across the country. Only in Virginia were concerns raised about the final version of the Ninth, but it was Virginia. And if Virginia was saying no, well, that was going to cause a problem probably in other places, or just hold the whole thing up. And, well, it was going to be a domino effect. They were very, very concerned about that. Again, those concerns in Virginia, they delayed ratification for 2 full years. So enter James Madison. It's early 1791, and there's a debate raging in Congress over Alexander Hamilton's proposal for a legislation for a bill to establish a national bank. So on February 2nd, 1791, just over 10 months before the Bill of Rights were eventually ratified, Madison gave another speech in Congress, but began his argument by laying out a fundamental rule about the Constitution of limited and delegated powers. He said, an interpretation that destroys the very characteristic of the government cannot be just. Madison described it in Federalist 45 some years earlier as a document of powers that are few and defined. Everything else was reserved to the states or to the people. And so if you were to interpret this in a way that ran counter to that explanation that everyone decided or agreed upon, that's how they ratified the document, well, this is unjust. It's wrong. He then reminded everyone about the deal to ratify, that this was going to be a system of federal power that would be strictly interpreted, few and defined powers. He said the defense against the charge founded on the want of a Bill of Rights presupposed that the powers not given were retained, and that those given were not to be extended by remote implications on any other. See how these two kind of rules of construction are always put together by James Madison. On any other supposition, he said, the power of Congress to abridge the freedom of the press or the rights of conscience, etc., could not have been disproved. Then he says, don't take my word for this, that we agreed that the ratification was done on this understanding. Here are some of the records from Pennsylvania, Virginia, and North Carolina to prove it. He said the explanations in the state conventions all turned on the same fundamental principle, and on the principle that the terms necessary and proper gave no additional powers to those enumerated. And there he read, this is from the notes, read sundry passages from the debates of the Pennsylvania, Virginia, and North Carolina conventions. And next up from Madison, the slam dunk. In case anyone forgot, we are putting it into writing. And then he read the pending 9th and 10th Amendments. The former as guarding against a latitude of interpretation, and he said the latter as excluding every source of power not within the Constitution itself. With this explanation, James Madison expressly linked the 9th and 10th Amendment as partners to jointly protect the reserved powers and rights of the states and the people themselves. And with that, much of the remaining opposition in Virginia was convinced, and on December 15th, 1791, Virginia became the 11th state to approve the first 10 amendments to the Constitution, known today as the Bill of Rights. So the 9th Amendment wasn't a tool to expand federal power. It was a rule of construction meant to explain the limits of federal power, a partner to the 10th Amendment in support of both individual rights and the right to local self-government, incredibly important stuff for the founders and the old revolutionaries. And here, in his view of the Constitution of the United States, St. George Tucker laid out how the 9th and 10th Amendments work together as a firewall against federal power. First, the 10th, he explained, was to guard against encroachments on the powers of the several states in their politic character and of the people, both in their individual and sovereign capacity. And then the 9th, about expansive constructions of power that attack or destroy your liberty and rights. To guard, he said, the people against constructive usurpations and encroachments on their rights. Put them together, the 9th and 10th Amendment, and this is what you get. He said, the sum of all which appears to be that the powers delegated to the federal government are, in all cases, to receive the most strict construction that the instrument will bear, where the rights of a state or of the people, either collectively or individually, may be drawn into question. And John Taylor of Caroline, some years later, in Construction Construed and Constitutions Vindicated, he made the same case that the 9th and 10th are partners for federalism. And again, he references them as the 11th and 12th. The 11th Amendment, he said, prohibits a construction by which the rights retained by the people shall be denied or disparaged. And the 12th reserves to the states respectively or to the people the powers not delegated to the United States nor prohibited to the states. And Taylor continued with this. The precision of these expressions is happily contrived to defeat a construction by which the origin of the Union or the sovereignty of the states could be rendered at all doubtful. And again, for Taylor, for Madison, and for so many others, the sovereignty of the states is really about the final authority of the people of the several states. The 9th Amendment was no afterthought. It was the final lock on federal power. It doesn't expand liberty from the top down. It protects against federal attacks on liberty from the bottom up. Alongside with its partner, the 10th Amendment, it completes the firewall that was demanded by the state ratifying conventions during the ratification debates. The Ninth Amendment doesn't compete with the 10th Amendment. It helps protect it, and vice versa. Together, the Ninth and 10th Amendment lock in a core principle: delegated powers only. Everything else stays close to home or with the individual. Unfortunately, the government-run and government-approved education system never teaches much of this, if any of it at all. And that's a huge part of the reason why we work so hard every single day to reach and teach more and more people about these essential principles from the founders, from the old revolutionaries, about the Constitution, about liberty, how to defend both when government refuses to do so, which is, well, 24/7, 365. And nothing helps us do this work more than the financial faith and support of our members. If you got a couple of bucks of that quickly devaluing, dirty government fiat, please consider throwing it our way over at 10thamendmentcenter.com/members. Our membership program starts out at just $2 a month. We also have annual, 5-year, and lifetime options. Again, it's 10thamendmentcenter.com/members. It's all spelled out. I'd be extremely grateful for any consideration you can give to joining us as a member today. Now, if you don't want to become a member but still want to help us out financially, that's pretty awesome too. I'm very grateful for whatever you think works best for you. Or if you're already a member and want to pitch in additional, again, thank you for your membership and your support. You can make a one-time contribution, whether it's by that dirty government fiat online. You can mail us a check or send us some sound money like goldbacks over at 10thamendmentcenter.com/donate. Again, all spelled out, 10thamendmentcenter.com/donate. Of course, there's a bunch of free and easy peasy things you can do to help us spread the word, primarily by triggering the algorithm of the platforms you may watch or listen on. On YouTube, for example, watch time percentage is a big one for the algo these days. If you got a 10-minute video and you watch it for 8 minutes, that's 80%. It's decent. But if it's 20 minutes, that's 200% and way more awesome. You can also leave us reviews on Apple Podcasts or any other podcast platform, comments in the archive, like, subscribe, notifications, sharing links, etc. All the stuff that you can do to interact with these various platforms. I'm very grateful for your help. I'm so grateful that you wanted to spend some time with me today. I hope you enjoyed this episode. It was interesting. I hope it made it fun to watch or listen to from time to time. I do my best to at least make it a little entertaining, so it's not just a historical lesson for you. But more important than anything, I hope it made you think, and I hope you learned something. Again, thank you so much for spending some of your time with me today. I hope you have a great rest of your day, and I look forward to seeing you next time here on the Path to Liberty.